I was told at 8:45 this morning that you were refusing to attend court. I ordered that you had to be brought. You do not want to be here, but it is not your choice. You have to face the consequences of your actions, to hear the court's sentence passed in public, and it is important for those who loved your victims to see you sentenced. The facts underlying these convictions are chilling.
Well, a magical moment, if you ask me. So I didn't introduce you, don't I? It's barrister and broadcaster Andrew Eborn, a man who knows a thing or two about the way our courtrooms work. That was a significant moment on the part of Mrs Justice Cheema-Grubb, wasn't it? Good for her.
Good for her, and it was a very measured judgment. And what I liked about it was about 45 minutes where she unpacked the case, all of the circumstances, went through the rules and regulations. And you'll remember I spoke about this beforehand, about Sarah Munro was the first judge to do this when the rules were changed about broadcasting sentences. And the whole idea is to get trust back in the judiciary so people understand the cases. I always say trust comes in on foot but leaves on horseback, and trust in the judiciary, we had a number of cases where it was diminished as a result of, as you say, defendants not being in the dock, as a result of what appeared to be lenient sentences. So justice not just being done, but being seen to be done. And that's what happened. So 45 minutes, she unpacked the case. Horrible, horrible circumstances. All sorts of questions have been raised about access to firearms, the material he was seeing online, and so on and so forth, and working on that sort of basis. So questions need to be answered about that sort of side. But unpacking why he got the sentence that he did, and you compare it to other sentences, it explains what happens. And the starting point, they were talking about the difference between a whole life sentence, which means you never, ever, ever get out, and what's called a life sentence, but with a minimum term. And a minimum term, and that's what it is, it's a minimum term, doesn't mean it's automatically going to come out afterwards. It means it's at least 49 years before he can go to a parole board to decide whether he's fit to come out.
So this was the sentence. This was the... as I just said, there are two aspects to this. It's very important, in my view, that defendants should, I think, always face their sentence.
Absolutely.
That is the key moment in the case of the state against a defendant. A moment where the state dispenses its justice to someone who has broken its laws. Really important. The fact that we just allowed generations of crooks to just say, no, I'm not going to do that, I think is bizarre and kind of warped. But the victim statements, so last week, Kyle Clifford, the crossbow killer, he wasn't in court because the judge thought, oh, it'd be pretty bad to put a bloke in a wheelchair and go, but rubbish, who cares? Now here's the grieving father and the widower of those poor women who Kyle Clifford killed. The racing commentator, BBC racing commentator John Hunt, he reduced the entire court to utter tears. You could have heard a pin drop. His statement was stunning. Absolutely stunning. And the fact that Kyle Clifford didn't have to be there to listen to it, I think is a disgrace.
No, you're absolutely right. As always, it is a disgrace. And thank goodness, as you say, for Mrs Justice working on that sort of basis. She forced him. She said, I'm not going to sentence you until you're actually in this court. So all credit to her. And hopefully that will now be the pattern for the future. People need to be in the dock whilst they get sentenced and put down on that sort of basis.
Exactly right. And strange that for so long we allowed this. I think this emerged. I remember covering a story. It was some awful rapist, who chose. I read about it, and then we did a story on here on Talk, and I remember I said, "What do you mean? What, he just decided he didn't want to be there?"
No, what you and I spoke about it in this very studio. We did, and we looked at that sort of side. And you were saying at the time you would drag them up, handcuff them if necessary, and
but I think we should do that.
Yeah,
I think we should do that. They say, "Oh, we don't want these unseemly scenes." Okay. Clear the court if necessary. If necessary, put them in a damn straitjacket, handcuff them, gag them. Don't let them shout and scream. Gag them and make them listen. I mean, the state shouldn't be weak. At these moments, it should show its power. That is the whole point. This is the power of the state in action, and it should be seen.
Absolutely. And the other thing they were looking at is actually increasing the sentence if people still refused. I mean, you can still drag them up for the reasons you've mentioned, but if they still refuse, they would say, well, actually, that will go into making the sentence even tougher as a result. But you're absolutely right, and as I say, all credit to the judge in this case for making sure that happens, and hopefully that will be the precedent for what we've done, so people get a faith back in the system, and you need to work on that premise.
Let's just talk quickly about the sentence. Mrs Justice Cheema-Grubb drew some criticism for not sending Nicholas Prosper to jail for the rest of his life, a whole life sentence. Instead, he got minimum 49 years.
Minimum 49 years. So what it is, it's a life sentence, but they basically say you have to serve a minimum of 49 years. What that means is not automatically you come out. After 49 years, you go before the parole board, and they work out whether you could go out. If you do go out, you're still out on licence, so if you do something else again, you could be back in, and so on and so forth. So you need to look at that sort of side. But she was very measured in what she did, and there were three reasons. One, his age at the time. He was 18. You might remember Kudwara was 17 at the time and could have got a whole life sentence. He basically only got 52 years, I think it was.
Yeah.
You looked at that sort of base. He also pleaded guilty, which they said was a factor. And the thing they're talking about, he was thwarted in his mission. He wanted to do the biggest gun massacre of the century. That's what he wanted to do.
Yeah.
And he was thwarted in that mission. Basically, his mother woke up and saw he had a gun.
Bravely stopped.
And basically, he murdered his brother and also his sister as well. So the three of them. And they're saying, some of the reports saying that actually, had it not been for those three and their bravery, he would have carried on and gone to the school, his primary school, where he was going to intent on murdering little children.
It does. I mean, you know, I take all that on board. And, you know, I can't get too energised or furious about the fact he's got 49 years minimum. Could be more, don't forget. I mean, that does seem to be a pretty stiff sentence.
Yes.
But a lot of people say, well, look, what he did, murdered his mother, his sister and his brother in cold blood with a shotgun, off to murder, if he could have done, 30 little kids at a primary school. If that doesn't warrant a whole life sentence, what the hell does? But as you say, there are these mitigating circumstances, pleading guilty, not causing too much trouble to the system, as it were. But nevertheless, the Shadow Justice Minister, Kieran Mullen, has written to Lord Hermer, the Attorney General, asking or seeking an increase to this sentence, saying that it's unduly lenient. I wonder what will happen there.
Well, I can tell you what will happen, because the same happened with Rudy Cabana. They wrote to the Attorney General, Lord Hermer, and he basically said, no, it doesn't make sense. The judge acted correctly in that case. It wasn't a whole life sentence.
Mind you, Hermer is a lefty, isn't he?
Well, there we go. That'll teach you. But the reality was exactly that. So it would mean putting the victims and their families through more trouble. Was one of the things, one of his factors. And unless it's really obvious that the judge erred on the wrong side of the law, then it's difficult to overturn it. But the whole idea, and there have been 100 cases, and when we looked from 2021, where they have said the sentence was too lenient, and it has been increased as a result. So we want to restore, as I say, going back to the idea of trust in the system. The trust in the system, say if the sentences are too lenient, there is a mechanism for correcting that.
And a big thank you to Andrew Eborn. Excellent stuff, as always. Thank you, Andrew.